Hello and welcome. This is Legal Focus. On the show today, the money laundering trials of three associates of the 2019 PDP presidential candidate Atiku Abubakar take off at the Federal High Court, Ikoyi, Lagos. Plus, an exclusive interview with Abuja-based senior advocate of Nigeria, Jibril Samuel Okutepa. And later, we'll tell you more about the solution of marriages under the Nigerian legal system. Come along. First case to be called was that of Abdullahi Babalile. He had been arraigned on a 2-count charge of allegedly laundering $140,000 in February, days before the 2019 presidential election, on the suspicion of vote buying. The EFCC says he procured and aided one Bashir Mohammed to make the cash payment without going through a financial institution, as the money exceeded the lawful requirement. His lawyer, Michael Zekome, argued the bail application before the judge, asking for a liberal consideration with assurances that he wouldn't jump bail. Despite objections raised by the EFCC counsel, Ahmed Buhari, bail was fixed at 20 million naira with a surety and like sum who must be resident in Lagos with the necessary proof.
Bail, which is the right of an accused person who is presumed innocent until proven guilty, was not made onerous or unnecessarily burdensome. And in Babalile's case, he transferred the sum of 50 million naira for a project through a banking procedure, which is allowed, but that the person he transferred it to decided that maybe to make it ease of carrying cash, change it to $140,000. That's why this man has been brought here. And that man has been made a prosecution witness, that Bashir Mohammed. He, instead of him actually being the person in the dock, if you are giving naira transfer to take to a third party, and you now decided in your wisdom or lack of it to change the money to dollars, why are you punishing the person who did the legitimate legal transfer through the banking process? What has he done wrong?
The second case before the same judge concerns Mr. Atiku Abubakar's lawyer, Oyekwe Giwa Osage, and his brother Erose are accused of laundering $2 million. Like Mr. Babalile, they had been on administrative bail since their arrest in February until their rearrest before arraignment. The accused stated that they belonged to a highly reputable family and so cannot jump bail. They argued further that the said money is theirs and not public funds. The judge granted the request for the Giwa Osages to be placed in their counsel's custody, but added that they must perfect their bail conditions within 14 days. The international passports of the three accused must also be taken from the EFCC and deposited with the court registrar.
Federal Ministry of Justice, in a statement signed by the Solicitor General of the Federation, Dayo Akpata, have instructed the lawyers of the federal government to commence move to reverse the judgment delivered by the British Commercial Court, which ordered the seizure of 20% in assets of Nigerian foreign reserves amounting to $9 billion. Justice Butcher of the British Commercial Court, while delivering judgment in the suit filed by an Irish firm, Process and Industrial Development Limited, against Nigeria, gave the firm the go-ahead to seize Nigerians' assets to the tune of $9 billion in terms of judgment debt in favor of the firm. However, barely few hours after the judgment was delivered in favor of P&ID, Nigeria has indicated it to appeal the judgment. A statement from the Federal Ministry of Justice, signed by the Solicitor General of the Federation, Dayo Akpata, disclosed that the federal government have already instructed its lawyers to initiate appeal proceedings against the judgment at the British courts. Mr. Akpata, while assuring that the federal government shall do everything possible to defend vigorously its interest and that of the people of Nigeria, hinted that part of the move is to seek for a stay of execution of the said judgment adding that the issue is a current litigation issue at the United States of America. As regards the recent judgment of the English Court of 16th August 2019, the Federal Government Council have been instructed to pursue an appeal on the judgment of the English Court, at the same time seek for a stay of execution of the said judgment. P&ID had dragged the Federal Government and the Ministry of Petroleum Resources to court over a alleged breach of an agreement entered in 2010 by Nigeria to supply gas to a processing plant built and run by P&ID in Calabar. The agreement was for a 20-year deal, but the Nigerian government failed to keep to our own side of the agreement, prompting the legal action against the country. But in the statement issued to journalists, Mr. Akpata disclosed that since the matter came up, the government has continued to pursue the validity of its jurisdictional defense as a preliminary matter which must be conclusively resolved prior to any consideration of the merits argued up in the Court of Appeal. The federal government has continued to maintain that P&ID never began the construction of the project facility, for which it claimed about $40 million in preliminary expenses. The federal government said the firm's claim in the arbitration proceedings was mainly for loss of profit for the entire 20-year term of the GSPA, initially claiming the sum of $1.9 billion and later increasing its claim to $5.9 billion. Mr. Akpata, however, disclosed that though the arbitral tribunal had on 31st January 2017 rendered its final award against the Ministry of Petroleum Resources in the sum of $6.597 billion, together with a pre-award interest at the rate of 7% per annum, effective from March 20, 2013, and the post-award interest at the same rate till date of the payment, the government had challenged the decision. In granting the huge arbitration award against Nigeria, the tribunal decided the following: that the project would operate at 93% uptime during the 20th year of the GSPA, despite the well-known risks of operating such a project in the Niger Delta; that the average price of natural gas liquids, the main revenue earner for P&ID, assuming the GSPA had been implemented, should be based on an average oil price in excess of $100 per barrel over the 20-year life of the project. To apply a discount rate to P&ID's supposed lost profits of 2.65%, the same interest rate paid on the United States Treasury note, thereby adjudging P&ID, a startup company that never commenced any physical work on the project but planned to operate in the midst of the Niger Delta crisis, using a novel and unproven technology, a virtually risk-free investment. Upon the award, P&ID commenced recognition and enforcement proceedings of the arbitration award against the federal government of Nigeria in March 2018, both in the United Kingdom and in the United States of America. The federal government therefore demanded that the jurisdictional issue must be conclusively resolved before Nigeria may be required to litigate the merits of P&ID's petition.
In the Constitution, we have that right to freedom of speech, and we call it a fundamental right. It is called fundamental because it is enshrined in the Constitution, and the implication is that you don't take it away from citizens without justifiable reasons. Now, talking about drawing the line between right to freedom of speech and engaging in criminality. Now, you must understand that every right has its own limitations. That's why in law we see ubi use ibi remedium. Where there's a right, there's a remedy. No right is at large. Every citizen's right ends where another citizen's rights begins.
Someone came out a couple of days ago saying he wanted to organize a rally. Yes, of course, it tagged it as a revolution rally. Beyond the word revolution, what manifest intention can be associated with that use of term, with that use of expression? You cannot say. He hasn't even told Buhari to step down. He hasn't done that. He hasn't called for armed protest. He never did that. So before the government can begin to say this constitutes a threat to change the government forcefully, and then you look at the way the government clamped down on innocent protesters, seriously dragging men by these belts and all of that. Have they ever taken even a measure of that against other people that have also been beating drums of war? So beyond the issue of government trying to be proactive, at the center of this is the issue of sincerity of governance. And of course, when people are not in tune with the government, when they are at displeasure with the government, they have the right to protest. It's sacrosanct the world over.
Hello and welcome to the Advocate segment of Legal Focus, where we meet legal luminaries who have made their mark in the learned profession. Our special guest this week is the Senior Advocate of Nigeria, Jibrin Samuel Okutekpa. Good to have you on the program, sir.
Good to have you too.
Welcome, sir.
It's a privilege.
Sir, talk to us about your childhood. Let's get to know you. And at what point did you decide to become a lawyer?
My childhood is, I was born into what I may refer to as poverty. And I grew up in poverty, and I live with poverty. And poverty and I became friends. But when God chose to lift a man, he can do anything. So God lifted me from that dungeon of poverty to where I am today. So I didn't have the privilege of going to school. I was a farmer. I've been everything that any poor person should be. I was a roadside mechanic. I was a taxi driver. I didn't have the privilege of attending formal schools, so to say. I recall my dad didn't want me to go to school because I was the only one farming. So I ran away to my maternal uncle, late Sergeant Amodu Ebunuwani, who was living in a place called Mararaba Baesa in the present Takum local government of Taraba State. Then he spoke to his friend, one Mr. Umuru Fonga, may his soul rest in peace, his too is late, who permitted me to write my first school leaving certificate examination along with other persons who were in the school. And so in 1980, I sat for first school leaving certificate and I came second.
Wow.
Out of the class. So by 1985, I went to School of Basic Studies to study economics, government, and Christian religious studies at advanced level. And I came out in 1987 with 11 points. That was the result that I got admission to read law in the prestigious University of Jos.
Interesting.
And then became qualified as a lawyer by the grace of God in 1991, December 12 to be precise. And then from December 12 till today, I've consistently been in and out of court, except on non-juridical day. So, and by the grace of God, on the 7th of July 2011, I was found worthy in knowledge and character and in learning, and I was conferred with the rank of Senior Advocate of Nigeria.
Okay, sir, kindly take us through your era of apprenticeship as a lawyer.
Yes, there are so many stories, but let me cut it short. My first principal is Mrs. Francisca Ebofami Neza. Is married to my very good friend and my brother, Mr. Matthew Okwen Neza, the man whom God also used to make me who I am today. That's the story of another day. And so I started my pupillage with Mrs. Neza the very moment I was called to bar. I stayed with her for some times. Then I got another employment with another second principal, E.A. Aruna, Emmanuel Akue Aruna, also in Makurdi. And by 1st April 1993, I got permission from my second principal to set up my law firm. Then I set up my law firm on the 1st of April 1993 under the name and style of Agama Okutekpa & Co. At number 51 Railway Bypass, High Level Makurdi. And I practiced there for a long time under very tough but satisfying environment because under Benue judiciary that I trained, it was a judiciary headed by the then Chief Judge, Honorable Justice Alas Indoko, judiciary that was second to none. If you go to court, you come back, you see juries of credit and repute, people like late Aboy John Ikongbe, who ended up at the Court of Appeal, Justice of Court of Appeal, and died. People like Adam Onum talk about His Lordship Honorable Justice A.J.M.B. Ekonau of the Supreme Court, late Justice D.T. Ahura, and J.S.K. of Court of Appeal now, and my Lord Justice Tinetu talk about other jurists. So those were lawyers. And then let me not forget the judge that I first appeared before his court. And he was a judge that has all the embodiment, all the attributes of a judicial officer. Late Justice E.O. Ogbole of blessed memory. He was the first judicial officer that appeared on the 19th of December 1991 in a matter involving Radio Benue. Our client then was Ms. Honorable Tayem Bashija. He's now a professor. We have a case against Radio Benue. And I had the privilege of appearing against one of my very close friends, Professor Agbo Madaki, who had thought that I was a senior lawyer, and the argument was flowing, and His Lordship Justice Ogbole listened to me with the patience of a judge. And I came from law school with the theory of law, but I didn't appreciate the practice of law, although I lost the case. But my learned friend, Chief Agbo Madaki, took me out for lunch. That he's not seen a lawyer like that. And he asked me how old I was, and I said, no, this is my first appearance. So he was excited and took me out for lunch. So then I was with my first principal, Mrs. Neza. It was our case.
By looking at your experience and journey so far, any regrets, and also how would you define the Nigerian judicial environment?
Well, if I have a choice to come to this world again, I will come as a lawyer. I have no regret being a lawyer. Being a lawyer is a privilege bestowed on you by God. And like I have always said, it is only the legal profession that is the light of the society. And when you belong to that profession of noble men and women of virtues, there are a lot of responsibility bestowed on you, one of which you must be consistently consistent in your integrity. You must not pollute the stream of justice. And I'm happy that even when poverty was written all over me, when I became lawyer, I didn't have the temptation to corrupt any judicial officer or to negotiate with any adversaries or to take any pecuniary benefits from any matter I was briefed to handle. So any matter that I had decided to take when I became a lawyer, I did those cases with a commitment of an evangelist. It was as if my life depended on it. So because looking at my background from where I come from, and a man without formal education. This Nigerian society where people are faced with all manner of injustices here and there, I propose that anyone that briefs me or anyone that I take up his matter, I would do it with the commitment within the ambit of the rules of professional conduct, and then ensure that justice is done. So I have no regret being a lawyer. Now, back to the other question of looking at Nigerian judiciary, the environment.
Yes.
I think, speaking for myself and speak for the benefit of eyesight, I think Nigerian judiciary is operating under very excruciating and very polluted environment. And I give kudos to Nigerian judicial officers. Indeed, the environment under which they work offer them the temptation. And it can only take the spirit of a Joseph being on the bench to resist advances of Potiphar's wife, because you know that Nigerian environment offers itself for corruption. Even as a lawyer, sometimes you hear clients coming to say, what will you do for Judge H or B? If you are not a lawyer of integrity, most of these clients will lure you to go and commit some conduct that are unbecoming of a legal practitioner.
Sir, have you had that experience?
Except you are not in Nigeria, there will be a temptation. But you must purpose in your heart, like Daniel of the scripture, not to defile yourself with the king's meat and the king's wine. So you must take vegetable. And when you take vegetable, you are fresh. So when they come speaking to me, I say, sorry, I've never done, and I do not intend to do, and I will not do it. Because if you agree to do it, and mark you, under the legal rules of professional conduct, you are not to advertise yourself. You won't see signboard. So my advert is my integrity.
Yeah.
So if you come to tell me this is what you want to do and I say I will not do it, you carry the tail. But if I agree to take money from you and say I want to go and bribe a judicial officer, you will be the one to tell that Mr. Okutepa you see is speaking jazz. Back to the story of your question. The environment is not conducive for judicial officers, particularly our political class. They do not believe that a judge can give judgments without being induced. So, we as lawyers, we need to advocate for the environment for judicial officers to be improved upon. In those days, judges live in GRAs. You don't visit judges anyhow. Judges don't go for functions. Judges don't go to welcome president and governors at the airport because they are special breed of person. Yeah. And there's a theory of law that you mustn't give an appearance. And when there is an appearance of impropriety on the part of a judge, he is disqualified from adjudication. So, judges have to train themselves also not to give appearance of impropriety. And that's why I found that sometimes you see judges who receive calls from prominent politicians or going to lobby prominent politicians for employment for their wards. By the time you do so, you have opened up yourself to a lot of temptations because, like late Abiola said, the hand of the giver is always on top. So when somebody is giving you something, it's on top of you.
Who can dissolve a marriage? Where can marriage be dissolved? Again, under the Act, under the Matrimonial Causes Act, and under the Marriage Act as well. Marriage under the Act, which I had earlier explained in our last edition, either marriage in the church, marriage at the marriage registry, and so on, can only be dissolved by the High Court. And for the purpose of the Matrimonial Causes Act, the High Court has a single jurisdiction, meaning that either the High Court of Lagos State, the High Court of Zamfara State, the High Court of the FCT, and so on, they are deemed to be one jurisdiction under the Matrimonial Causes Act, for which proceedings can be initiated for the purpose of dissolving marriage. But in determining this question of jurisdiction, two factors are usually considered. We have what we call the lex locis celebrationis, which is the place of celebration of the marriage. We also have the issue of domicile. Where do the parties live? Apart from where the marriage was celebrated, is either of the parties residence within the state where the proceedings are to be initiated. There are a series of processes that have to be exchanged between the parties until pleadings are closed. The court will now have to entertain the proceedings, take evidence, and determine whether the grounds under Section 15 of the Matrimonial Causes Act has been fulfilled. Once the court has reached that decision, the court can now make an order dissolving the marriage. Apart from dissolution, where these factors under Section 15 are present, the other alternative available is what we call judicial separation. Judicial separation can arise where a party, while still married to the other, intends to live apart legally by seeking the permission of the court to stay apart from the other. Under Section 39 of the Matrimonial Causes Act, there are various requirements and conditions that have to be fulfilled. We may not have the time to explain that in detail, but let us note that there is also the relief of judicial separation. We also have jactitation of marriage. Jactitation of marriage is a situation where somebody continuously boasts to the public, somebody continuously announces that he or she is married to some other person, whereas such marriage does not exist, whereas they may not even be intention to get married. The law allows the person against whom this act of boasting, an act of public announcement of non-existent marriage, to go to court to get an order to restrain that person from continuing to make such statements. Again, we also have what we call breach of promise to marry, which can also be initiated. But for you to prove that someone had promised to marry you, the law says you must do that by documentary evidence. That promise must have been in writing. You must be able to exhibit it. You must be able to prove it. Finally, I want to say that where the grounds for dissolution of marriage is on grounds of adultery, the law requires mandatorily that the petitioner must join the co-respondent. The co-respondent now is the person with whom the respondent committed the alleged adultery. Take, for example, where the wife is the petitioner, the husband is the respondent. The wife is alleging that the husband has committed adultery. The law says the woman with whom the husband committed adultery must be joined as a party to the proceedings. That person that is joined can now be referred to as the party cited, otherwise called the co-respondent. Failure to join that person will render that petition or that ground of the petition void. It cannot be established. This is a mandatory requirement under the law. Again, I need to say that where that adultery is successfully proved, the petitioner is entitled to claim compensation from the person with whom the respondent committed adultery.
And that's Legal Focus. Thank you so much for watching. See you again next time. Bye-bye.